There's a region in Alabama called the Black Belt. It originally got its name from the rich, fertile soil which is abundant in the region, which makes it ideal for planting crops like corn, peanuts, and in the early years of the United States, cotton. It's a 23-county region that spans from east to west across the southern and central parts of the state. Remember this map, please, because it's going to be very important for the context of the rest of the story. Slave plantations once thrived there, which meant that a high concentration of enslaved black people ended up in the area. And to this day, much of the state's black population still lives there. As a result, the Black Belt took on a second meaning, one that has political implications. Located along the Black Belt are some of America's most historic towns and cities, including Montgomery, considered the birthplace of the civil rights movement. That's where Rosa Parks was arrested for refusing to move to the back of the bus, which sparked the Montgomery bus boycott. Also located in the Black Belt is Selma, where civil rights activists began a protest march that culminated with Bloody Sunday in March of 1965, when law enforcement attacked the marchers at the foot of the Edmund Pettus Bridge. Images of the brutal attack shocked the nation. It garnered support for the marchers and the cause they were fighting for, the right for black people to vote and for their votes to count equally. The Selma March laid bare why it was necessary to enact legislation that would guarantee that right. Just days after Bloody Sunday, Congress prioritized the passage of the Voting Rights Act, which Lyndon B. Johnson signed into law later that summer. Fast forward to today, 61 years later, and Alabama might be where the Voting Rights Act dies, too. Alabama has a history of diluting black voting power by gerrymandering the congressional districts along the Black Belt. Following the 2020 census, the Alabama state legislature drafted a new congressional map in 2021 that included one black majority district, District 7. You can see it there, bottom left side of the map, the green district. It's located along the western half of the Black Belt. Makes sense. The eastern half, however, was broken up among three other districts, some of District 6, but primarily District 2 and District 3. A group of Alabama voters sued, accusing the state of racially discriminating against black voters, which would be in violation specifically of Section 2 of the Voting Rights Act. And the case made its way all the way to the Supreme Court, which affirmed in 2023 that, yes, Alabama's map was illegal. So the case was sent back to a lower court, and Alabama was ordered to create a new map. But the new map that they submitted was not that different from the previous one. You can see it here. The maps look pretty much the same. District 7 in green expands just a bit to the south in the 2023 map, but the demographic makeup of the districts didn't meaningfully change. The federal court overseeing the case rejected it and appointed a special master to take over the creation of a new, actually fair map, which included two black majority districts, District 7 and now a new District 2, both in green, you can see them there, located along Alabama's Black Belt. This is the map that the state used for its 2024 elections, and for the first time in its history, guess what happened? Alabama elected two black lawmakers to the House of Representatives in the same year. Still, Alabama decided to continue challenging the case and pursued it to full trial in February of last year. That hearing lasted 7 days. The court heard live testimony from 17 witnesses. It reviewed more than 1,000 pages of briefings and more than 350 exhibits. And ultimately, the three-judge panel of the District Court of the Northern District of Alabama, which included two Trump appointees, concluded that the state had engaged in, quote, an intentional effort to dilute black Alabamians' voting strength and evade the unambiguous requirements of court orders standing in the way, end quote. Okay, so it's pretty clear that the courts keep saying that they were trying to do, that we're doing the wrong thing in Alabama. But all of that work is being undone in the aftermath of the Supreme Court decision in Louisiana v. Calais, which is a similar case of racial gerrymandering that was decided by the Supreme Court in late April. It effectively gutted Section 2 of the Voting Rights Act, severely narrowing what the courts may consider to be race-based discrimination. But we're still in the process of finding out the full extent of that decision. In the wake of the Calais ruling, Alabama went back to the U.S. Supreme Court. It wanted to get rid of the court-enacted map that created the two black majority districts that you're looking at on your left in favor of the older map that the district court found to be racially discriminatory, the map with only one black majority district. The Supreme Court entertained the idea. Last month, it ordered the district court to reconsider the case using Louisiana v. Calais as the new guidance. So the three-judge panel at the district court reviewed the case again, and it held its ground. Quote, our previous review of the undisputed evidence left us in no doubt that Alabama's legislatively enacted plan intentionally discriminated based on race in violation of the Constitution. Our re-examination in light of Calais yields the same conclusion, end quote. I mean, how many times you got to lose a case in court before you get the message? But that wasn't good enough. In an unsigned order released this week, the Supreme Court's conservative majority ignored the district court. They ignored what I just read to you and told Alabama that it can go ahead and use the map that it wants to use. Despite years of review and a full trial overseen by the district court, signaling that it is now effectively impossible to challenge racially discriminatory gerrymandering or other voting practices in the aftermath of Louisiana versus Calais. Joining me is Melissa Murray. She's a professor of law at NYU and an MS Now legal analyst and co-host of the podcast Strict Scrutiny. She's also the author of the new book, The U.S. Constitution, a comprehensive and annotated guide for the modern reader. Melissa, welcome. That was a lot of explanation, but sort of necessary to make the point, right? That Section 2 of the Voting Rights Act says you can gerrymander for certain reasons, including partisan reasons, but not for racial reasons. There are people who make the case that, first of all, in places like the Black Belt, those two things are very similar.
Well, virtually indistinguishable. So the court in an earlier case, 2019's Rucho versus Common Cause, said that there's nothing for federal courts to do vis-a-vis partisan gerrymandering. So effectively, states are doing it, and they can do it, and the federal courts can't do anything about it. The problem in the South, and in other parts, but especially in the South, is that partisan affiliation is often inextricably intertwined with race, which is to say that in places like Alabama, like the Black Belt, whites tend to be Republicans and blacks tend to be Democrats. So if you are organizing your congressional districts to consolidate partisan advantage, you are doing it in a way that will disadvantage minority voters in the South. And the court in the Calais case really prioritizes partisan gerrymandering, which is perfectly permissible to do, and says, like, we can't really figure out if it's racial gerrymandering. It's probably partisan gerrymandering without really understanding or at least acknowledging that the two often run together and are indistinguishable. And so the court in Calais says you've got to show intentional discrimination here, and I don't see that.
You have to prove that you're actually doing it to minimize black representation.
But here's the thing. States aren't dumb. Right? They're not going to be like, you know what, I would love to disadvantage my black voters. So they all say, actually, we were just doing this to consolidate Republican advantage. We were doing this to ensure that incumbents can continue to win. And that's why we did it. Those are permissible grounds, and the court ignores the racial undertones that undergird it.
So one watching the show might say, we would rather there not be partisan gerrymandering or racial gerrymandering. That would be great. Right? That would be fine.
That would be great.
But what has Louisiana v. Calais done? It's narrowed how the court can interpret this.
The court has purposefully narrowed it, which I think is important to understand. Louisiana versus Calais is a watershed moment, and it has really narrowed the moves that minority voters can make to challenge either under Section 2 of the Voting Rights Act or the Constitution itself to maximize their opportunity to elect the candidates of their choice. I mean, and the other thing that I think is really important to emphasize here, and your lead up really made that clear, we had lower federal courts, which included Trump appointees. The three-judge panel had 2 Trump appointees here. They had a hearing. They addressed this question very thorough, and they're closest to this evidence. And the court, which is often the case in these voting rights cases, and we don't call it out nearly as much as we should, the court constantly second guesses these lower courts that are closest to this record evidence. Like the lower court said was like, okay, you told us to come back and look at this in light of Calais. We looked at it. Yeah,
and
it seems like Alabama's doing intentional racial discrimination.
Because I don't follow this as closely as you do. I didn't know that happens a lot, that when the court says to the lower court, look at it, and the lower court says, we looked at it, we're good.
So this happens a lot in voting rights cases where there's often a voluminous record. Like these cases are very fact-intensive, very evidence-heavy, because you have to show that the state is doing something nefarious here, like something purposeful. So there's a lot of evidence. Justice Alito, who wrote the opinion in Calais, is almost always very skeptical of the lower courts and their fact-finding in these cases. And he's almost always challenged by Justice Jackson, Justice Sotomayor, who incidentally are the only members of the Supreme Court who were district court judges before and understand how records are compiled, how district courts do their work. So, you know, part of this is, I think, a neglect of the principles of the Voting Rights Act and their desire to ensure that everyone has an opportunity to be heard and that their votes aren't diluted. But also, it is a huge kind of middle finger to lower courts that are doing the work and genuinely are trying to suss out what is going on here. This court is like, we know best.
Yeah.
And they've constantly done that.
Melissa, thank you for your clarity on this issue, because I think it's just one of those things that gets by a lot of people because we haven't thought about it. It's one of these things that, well, people threatened. They warned us that this was going to happen, and then it happened, and now we're dealing with the actual circumstances, very specific circumstances, because, as you know, I cover primary nights at the big board, and some of these places, the primaries have been canceled, they've been suspended, they've been postponed. Some people have cast ballots in Louisiana that now are not valid because the districts have changed. This is really, with 149 days to go until the midterms, a very confusing situation. Melissa Murray is a professor of law at New York University and an MS Now legal analyst. She's also the author of the new and important book, The U.S. Constitution, a comprehensive and annotated guide for the modern reader.